Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast.
Rett, thanks for joining me for this episode of the Future of Resolution podcast by Miles Mediation. It's great to have you with me.
Thanks, Matt. I appreciate the invitation and look forward to getting back together and talking about this topic about business divorce today.
Yeah, thanks, Rett. So for those that don't know, Rett Peaden is a partner with the law firm of Smith, Gambrell Russell. He and I have known each other for quite some time. In fact, he and I were previously law partners. Since then, we've gone our separate ways legally and professionally, but we've definitely remained friends and stayed in touch. Very much looking forward to this conversation today as well, Rett. Can you start off by telling the audience a little bit about yourself and your practice?
Sure, Matt. I'm a partner over at Smith, Gambrell Russell, and my practice centers on corporate law and mergers and acquisitions. I'm the co-head of the M&A section at SGR and get to see a lot of the corporate issues that come through the practice. And, a lot of that is in the business divorce or people who are trying to split up their businesses. And so get to see a lot of that comes through the door. But my practice is, again, M&A, general corporate, outside counsel for some of my clients. I work with a lot of clients who are coming, making inbound investments from international companies. And I have a tax background as well. So I help a lot of clients with structuring their businesses or structuring their deals on the front end to try to minimize taxes and help with an efficient corporate structure. And so that's what I do. Matt and I started out very early, young associates together, and continued to stay in touch through all this time. And so it's a pleasure to be here this morning.
Thanks, Rett. Today, I'd like to focus our conversation on the concept of business divorce. And you and I have talked about this topic quite a few times over the years through working together on matters, but also I know that this is a topic that we both touch on professionally pretty regularly. So I wanted to talk first about what do we mean when we say business divorce? Usually when people hear the word divorce, we're talking about, marital discord and folks falling apart. Unfortunately, I guess in the business world, it's not that different. How do you kind of frame the concept of business divorce, Rett?
Well, I think there's a lot when you say the word divorce that applies when businesses are splitting up. And in a lot of divorces, businesses do get split up. And it can be a very difficult time for the owners of the company when this happens. It can become very emotionally charged. And it's not just always about the money or about how the business should be run, but it gets very personal. So there are a lot of reasons why businesses can be split up, and some of those are very legitimate business reasons, but very often it does become a contentious process. And so I think that's why the term business divorce is appropriate in this context. You can talk about businesses breaking up, but just the word divorce, when people aren't always at the best point in their lives, and that can very often be the case when partners are having to dissolve their business relationship.
Yeah, I would agree, Rett, with the concept of divorce and the emotion level here with business owners. Oftentimes business owners have a lot of sweat equity in the companies that they've built through the years. They have a lot of time and energy investment, and they have a lot of trust in the folks that they're working with. And when you have partners that have that trust erode, or you have partners that are no longer happy with the way things are going, friction and a good amount of contention provide for a recipe for a really long and expensive litigation battle if it's not planned out ahead of time on how it will be handled.
That's right. And I think it's also similar to a marriage when business partners get together, and that oftentimes they have very rosy pictures about how life together is going to be and how the business is going to do well and conquer the world. Everyone's going to have a lot of wealth, and rising tide lifts all boats. And for a time that may work out, just like you have the honeymoon phase in a marriage. But unless you've got a prenuptial agreement in place as a married couple, when things do go south and people decide to go their separate ways, you don't have kind of a roadmap about how that's supposed to work. Like you said, it can become litigious, it can become expensive and drawn out. And I think that's very, very similar with business partners. when they start out, very often they're not planning for failure. And that becomes a problem down the road if you haven't tried to anticipate those problems when people have less emotions involved, when they can be a little more reasonable, and when no one really has committed anything much up front. Before you kind of go down that path together as business partners, you need to plan ahead for contingencies that may not be the easiest to think about right now, but it's going to be easier to think about it now than if you have to do it 5 or 10 years down the road when maybe the company isn't as successful or somebody's leaving and taking business away, when all these other considerations get in the way of trying to frame a reasonable resolution to the dispute. So I think in that sense, marriages and business partnerships are very similar.
And I would add to that to some extent, all contractual relationships have that same framework where agreeing to terms is a lot easier at the beginning when you're forming the relationship than it is at a time of contention. So you're in a divorce situation, in a business divorce situation, obviously you have the added strain of having the emotional component to it. But in all contractual relationships, it's a lot easier to, on the front end, deal with the problem rather than trying to backfill at the end of the day when a dispute has already come up.
Right. And I think there's another element to this to consider as well, which is similar as to, when a married couple is trying to figure out a prenuptial agreement, they're not yet contractually united in marriage, and each one can kind of look after their own interest and negotiate an agreement between them. Whereas once they're married and they try to get a postnuptial agreement, there's a lot more duties they owe to each other, and being fair and transparent and loyal to each other, and it makes those agreements harder to enforce. And there's a little bit of a similar thing going on when we talk about businesses. So every state is a little bit different, but there are certain duties that you owe once you're a partner with someone, whether you're in a limited liability company, whether you're in a corporation, you're serving on the board together, you're an officer of the company. There are duties that the law imposes on you, and some of those duties you may be able to waive in advance, and when you're setting up the company, but some duties you can't waive in advance. So again, when you're negotiating with a potential business partner on the front end, you're really free to make whatever relationship how you want it to be, what duties you owe to each other, and you have a lot of freedom to contract on the front end. Once you are involved in a business partnership, and maybe you're serving on the board, you're a manager of the company, you're no longer just representing yourself. You have a third party involved, which is the company. And since you're tied together through the company as co-owners, there are certain duties that you owe to one another. And, if you start neglecting those duties, you could somehow find yourself at fault. You would, find yourself, behind the 8 ball when you're trying to resolve the disputes. If you have to go in front of an authority or a judge to make a decision, and you don't have clean hands, and it may be it may not be intentional, but just as you are approaching the relationship and trying to advance your own interest, if you don't try to take into account the company's interest and the company's well-being, you're really missing out on, everything that the law is going to look at when they look at the relationship between the co-owners, and then there's the business involved as well. So again, I think this just goes back to what you're saying before, Matt. On the front end, there's a lot more flexibility to try to address these problems and deal with them at arm's length. Once you get intertwined with each other as co-owners, it just raises exponentially the complexity of the problem of disengaging and disentangling the business.
I would agree completely, Rett. Let's talk a little bit about what happens if they don't do that. What if they don't plan properly? What are the consequences later on when the disputes arise? What does the litigation look like? And I think, I said early on that it's a recipe for long and expensive litigation. And one of the issues that I think puts that into play is trying to establish, one, the value of the business, and two, who's going to end up with the business?
Mm-hmm.
Is one partner going to buy out the other? Is it going to be sold to a third party? Let's start first talking about value. What are your options as a potential business owner dealing with it in a contract versus if it has to wait until litigation?
Right. Well, there's no one formula that works for every business when you're talking about how do you value it, what's the buyout going to look like, and that's highly negotiable. And a lot of it depends on the industry that you're operating in. A software as a service company is going to be looking at something entirely different than a manufacturer who makes widgets. It's just an entirely different ballgame when you talk about valuation, but it's also very negotiable. And you can one approach is to go out and get an appraisal on the company, and there's always a bit of a risk on doing that. You don't know where the appraisal may wind up, and that also can open the door for disputes on valuation if one party's not happy with what the appraisal determines. There are questions about can you have a valuation formula on the front end? But again, if you don't pay very careful attention to what's in those valuation formulas, it can have wildly different and unintended results. Do you have a funded buyout plan is an issue that we run into a lot. You may have a well-defined formula, but you haven't decided how you're going to pay for it. And maybe you don't have insurance to fund a plan, or you haven't set money aside for a rainy day, or you haven't provided for a period of time to pay out the purchase price. All of these things can affect valuation and what someone is able to pay for a partner's interest in the company. And you just have to be very, very careful in these formulas that they are addressing what the business is like and how it operates. I mean, if you're looking at book value is a very common thing to look at when you value a company, but book value may wildly, in some companies, understate what the company is truly worth as an ongoing concern and an enterprise if it continues in business. It's not just the dissolution value if you sort of shut down and sell everything at book value and distribute the proceeds. That may not be very appropriate for your business. So that's a long-winded answer to what seems at first a very simple question, but there's a lot there to unpack. And it's something that lawyers need to look at, but I would say they need to get their accountants involved as well and really seriously look at what's the best way to value their business, on the front end. Again, so you're not scrambling to try to come up with a way to value the business or relying on an appraisal that may or may not come anywhere close to what you think the value of the company is.
Yeah, I agree, Rhett. The concept there being one size is not a fit-all solution. The other two things I think that are in play there as well are, what are the personal liabilities that were signed onto by the owners? Did they personally guarantee debt, for example? It may be one thing to buy their interest at a stated value in the company. It's another thing to take them out of that debt obligation that they personally signed on for. So there's another hang up that I think frequently comes in and catches people off guard later on when they're like, well, wait a minute, I signed on for this $3 million note also. And the other partner's like, yeah, but that's not a part of your exchange here. I'm not indemnifying you out of a note obligation or taking you out of that situation. So I think that comes into play as well. I also think oftentimes when you get into business divorce scenarios, there are frequently allegations of wrongdoing at that point in time, whether they're founded or not. But a lot of that comes down to financial mismanagement in many cases. And when you're looking at book value and you're having an argument regarding financial mismanagement, oftentimes you get into the expense of having to deal with forensic accounting in order to get to your book value as well. So it's not even in the book value scenario, it's never as simple as it might seem on the surface. You have to dig down and apply what works best for that individual situation.
Yeah, I think that's right. And, just want to kind of touch on something you just mentioned, and that's, the allegations of potential wrongdoing. And, what I found is that, both sides may accuse the other of wrongdoing, and it gets down into, like we said before, the duties that people owe to each other as partners and the expectations that they have of each other in the business. And maybe one party thinks that the other party isn't, holding their weight or contributing fully. And that gets to people feeling they're being taken advantage of. And then they start thinking about the motives the other person might have. And again, there may be innocent problems at the beginning, but they can turn into very serious accusations. And what I've also found is that, like a lot of interpersonal problems, if you don't address them early on, you want to avoid conflict or defer conflict. And it really only makes the problem bigger down the road. It compounds over time, and the difficulty of addressing the problem only increases the longer you avoid addressing it. So an agreement or an understanding that's reached early on, even though it's an unpleasant conversation to have, it's better to do it now than when issues have compounded. Maybe the company's worth a lot more 2 or 3 years down the road. And I've seen situations where there's been complaints all along, and suddenly you're looking at trying to bring on an outside investor. And these problems always rise to the surface when an investor is doing their due diligence in a company. They're going to find out about the problems, and they're going to be very skittish about investing in the company then, and they don't want to have a problem in the ownership structure, and they're not going to invest if there are strong disputes between the partners. And a lot of times as well, what we see is that even if partners did have expectations of each other and they talked about it, talking about it doesn't really solve the problem if you don't document it. Because many times people have a short memory, and they may forget that they agreed that this was their arrangement, that one person was going to provide some money, the other person was going to provide some sweat equity. And then let's say the person provided sweat equity through the business, and they don't think that the financial investment that was made on the front end was worth half the company, because all they did was put in a little money on the front end. And if you don't document what the expectations are and how things are going to work and really think it through in detail, again, you could have people that are trying to act in good faith, but because they haven't both documented the situation and they haven't addressed it early on and been transparent all along, they come at loggerheads in the future, and both of them feel like they are acting with good motives and impugn the other person's motives. And yes, there are bad actors, but you don't have, two people who are both good actors can wind up through, no intentional, fault of either one in a business dispute. So I think it's important to document and to be transparent and clear and have the unpleasant conversations earlier rather than later.
Yeah, Rett, and following on that, so we've talked a little bit about the emotional aspect, which is how these disputes are destructive on a personal relationship level. Obviously, the longer those disputes go on, the more damage to those relationships that can occur. But let's talk for a moment, and following up on one thing you said. You were talking about how an outside investor looking in would see unresolved business disputes or business disputes that aren't accounted for in the operational documents of the business and look at that as a negative for investment. I would like to take that and build on that for just a moment and talk about how these disputes can be destructive to the valuation of the business. What I mean by that are a few different things. One, it harms the reputation of the owners to third parties, and you lose confidence in folks there. If the company's employees learn of a dispute amongst their owners, obviously that puts people finding themselves having to take a camp, so to speak, as opposed to being able to stay out of the fray. But in addition, it kills morale. Who wants to be in a business where the owners are coming in and fighting every day about what's going on? And then it causes third parties like customers and vendors to determine to have to sit down and determine a little more clearly as to whether or not they want to move forward with the business relationship as well. So how do you account for those situations so that destructive effect of a business dispute doesn't become destructive to the business itself?
Well, you absolutely hit the nail on the head. Business partnership disputes can be immensely destructive of the value of a company. And you can watch, you just watch the goodwill that's been accumulated over a period of time through hard work and effort and investment just entirely dissipate once something like this happens. As you said, an outside investor is going to be doing due diligence. They're going to be doing, litigation, lien and litigation searches. And if there's been litigation, it's going to show up. Litigation, what's the end result? A lot of times is that the company has to be dissolved and liquidated. And we all know that when you have to do a fire sale of a company, you're not going to realize true value. People know that there's just like in a divorce, when you have to sell the family home and do it quickly and divide it, you're not going to fetch the best price on your home. It's the same way with a business. You want to sell a business that looks nice, it's pretty, it's like the house has been painted and it's been clean. It's the same thing with a business when you try to sell it or get an investor. You want to make it pretty. You want to make sure that the papers are in record, that you've got full set of documents, that the accounting books look clean, that the owners get along, the employees are happy to show up to work every day. All of that is going to show up when someone else looks at the business, whether they're trying to buy it or invest in it. And if you go through a destructive dispute process where there's litigation and that's on the surface, all an investor is going to see is either, hey, I'm going to stay away, I'm not going to invest in this company, or, hey, I'm going to be able to sit around and pick up these assets at fire sale prices when they dissolve, or they have to get liquidity to make a payment to buy one partner out. It's like sharks, circling the diver in the water. It is not a good position to be in, and you want to avoid it if at all possible, because it's just a way to shoot yourself in the foot if you wind up in one of these situations that was avoidable had you done some planning on the front end to provide a process, whatever that might be, whether that's binding arbitration, whether that's mandatory buy-sell provisions in an agreement. All of those are alternatives to winding up in a destructive dispute with no clear out.
I totally agree. And I want to touch more on the ADR aspect in just a few moments, but I wanted to kind of expand on our conversation for just a moment. We've talked a lot about the business divorce concept flowing from discord between the existing owners. And I just wanted to touch on the fact that I think there are a few other circumstances in which business divorce come up and can be accounted for if planned properly as well. And I think you and I've referred to these as the 3 Ds on many occasions, but you have death, disability, and divorce as well that can cause a situation where you had a business partner that passes away and now you have an estate to deal with, or you have a business partner that goes through an actual marital divorce and now you have a former spouse that you have to deal with, or you have a partner that becomes disabled for some reason and is no longer able to perform services for the company. So there are other alternatives as well. Rett, how do you count for the 3 Ds when you're dealing with a business formation or getting the paperwork for a business in order?
Right. Well, and the problem with a lot of the 3 Ds is that you're dealing with someone that you didn't think you were going to be dealing with when you first started out the business. And if I could, I'd add a 4th D to that, which is deadlock, which is if you've got, 2 or 4 partners or however many, and you can't come to a decision. And, that's the default when you can't come to the decision is you stay with the status quo, and that may not be acceptable for one or more of the parties and may not be good for the business. So I would make that the 4 Ds. And, what's the best way to deal with that? I think that you really need a good set of legal documents when you start the company, whether it's a shareholders agreement, a operating agreement, a voting agreement. You need, in broad term, you could call that buy-sell agreements. There's a lot more that goes into an operating agreement or a shareholders agreement than just buy-sell provisions, but that's generally what we would refer to it as. And it's a way that you address those issues on the front end and you say, well, if my partner dies, should that trigger a buyout, or is the expectation I'm building this business for my family in the future so that they can benefit from it? Or If I sell out, am I getting an adequate price? Is it going to be funded? Is there going to be life insurance for the partner that dies? Disability as well. Is this the type of business where if an owner dies, it doesn't really make a difference because he's not providing a lot of personal services in the company? Or is this a business where we probably need disability insurance, and if an owner is disabled, he really can't be an effective owner because we were expecting him to go out and sell or do work like you might have in a service partnership. So, again, it's planning on the front end. Divorce, again, are you expecting that, you're only going to be doing business with your partner? Or is this the type of business it doesn't matter who owns the shares on the back end? We're all kind of financial investors. And what this also gets into, Matt, is what is your intent when you start up the company? Is this supposed to be a company that we are going to operate? Sometimes you call it a lifestyle business, but you expect to work in it, and you're taking out money proportionate to the effort you put in, like a service partnership. Is this a business that you're setting up to, be a source of multi-generational wealth? Maybe you want your children to work in it one day. It's a family enterprise. And maybe divorce is exceptionally important in this context because you don't want your, son-in-law or daughter-in-law to be involved in the business. It really is just for your family. And you're setting it up for that reason. Or is this a business that you're just trying to grow quickly and maybe get some investments down the road and go through a process and eventually build it quickly to scale and sell it and move on? So there's a lot of what you try to do with the legal documents on the front end and the problems that you address have to do with the type of business that you're trying to set up. And so in the context of whatever your goals are at the beginning, a good corporate lawyer can craft a set of documents that addresses each of these issues, the deadlock and the other 3Ds, and provides a way that we can, de-risk the transaction. We can provide options and flexibility, and we can try to steer any potential disputes into a more reasonable outcomes. Because at the beginning, when people aren't as invested and things aren't as emotionally charged, we will hit on better outcomes than we will in the midst of a crisis. So I think that it's key and critical to get good advice on the front end, but also for the business owner and the person who's starting up the company to really, we make fun of it sometime, but you got to do some navel gazing and really think about why you are doing this business. What is your goal at the end of the day? And what would be a successful outcome from this business? And then we can kind of construct the legal processes and document around that so that it's customized to whatever the client's intent is.
Yeah, Rett, nothing worse than having two entrepreneurs working together, one looking at it as a lifestyle business, one being a serial entrepreneur who likes to form, grow, and sell quickly, to find that out later on, as opposed to going into it as to how they want to look at this particular business. So definitely wise points on that as well. Wanted to shift the conversation momentarily here for ADR purposes. And what I would like to talk about are the benefits of handling business disputes like this, like business divorce cases, through what I believe to be first mediation as a good option, followed by arbitration. One of the things that I think helps this process is early mediation between the partners if there's a dispute. One of the aspects of that is that you can get to it quickly. You're not waiting through a backlog in the court. But also, before parties can charge up those emotions too hard, they have an opportunity to get into a room with a third party that has experience in that area that can kind of help wade through the scenarios and say, look, okay, here's option A and option B. Either of these would be good for you all. If you choose option C, litigation, here's what your likely outcomes are. You have a lot of time and money invested, and it's a very destructive process, and you may win. You may ultimately win on the issue, and have killed the golden goose in the process. So I think mediation provides an ability to get through it quickly without getting those emotions going. But I think that arbitration and mediation both also provide the privacy aspect of the dispute that can maybe help some of these things resolve more quietly and quickly without it becoming a huge issue that becomes a big eyesore for future sales or a big issue for employees to hang on to kill morale. Can you talk to me a little bit about your aspect and how you view ADR as it could apply to these types of disputes?
Right. Well, I believe that generally, especially on the front end and in constructing the organizational documents of a company, mediation and arbitration are to be preferred than to resulting in litigation. And the reason is just what you hit on. It's private, it's quicker to get to resolution, it's less expensive for the clients, and it's generally going to be less contentious. And what, again, the differences we look at from a planning perspective, mediation and arbitration. Mediation is a non-binding process, whereas arbitration is binding, and you agree going in that you will live by the results, whatever the arbitrator decides. So, mediation is something that sometimes people think they can do on their own, but it really helps to have a neutral party in there between them going back and forth to try to help settle the case. And a skilled mediator, from my perspective, can kind of be a second voice of advice to the client, because I can tell a client what their legal rights are, and they may believe me on one level, but having someone else come in and advise them, well, if you go into a lawsuit or you go down this path, here are your rights, here's what the agreement provides, and here's where you may wind out, and here's the alternative. So again, having a second neutral person behind me, and no matter what side in the dispute I'm on, having them kind of take a look at the case and be a realistic voice of reason to the client also helps the clients move towards resolution of their problems. So in that sense, I think having a skilled mediator and arbitrator is helpful in getting a resolution. And, again, mediation is something we try to do before we get to arbitration, because, again, we want the agreement to be consensual. We want it to be something that both parties buy into. But even in cases where you can't get a result in mediation, defaulting into arbitration, again, will be quicker, cleaner, generally, than going into a litigation posture.
And one additional benefit on the arbitration side is that you can pick an arbitrator that has a knowledge base that applies to the dispute, as opposed to allowing a jury to be pulled to pick from the options for you, and that jury may not be particularly interested in what it is that you do, what your options really are. Business disputes are not the sexiest disputes for juries, and you may have a pretty disinterested panel that may not follow along very well. So you get the expertise associated with your arbitrator selection as well.
And I think another thing to look at from a business standpoint between mediation and arbitration is mediation is not strictly bound by whatever the rules of law are. I mean, we are operating within law, obviously, but if we're probably in a dispute because there's a difference of opinion about what's provided under the governing documents. Well, maybe there's not. Maybe one party's being intransigent. But the point is, there's a dispute about what the documents provide. There's a dispute about what the law provides. And so it may not be 100% clear to the parties. Having a mediator help customize and fashion a solution for the parties that there's buy-in to, it may not be 100% what was under the documents or under the law, but people can walk away, with some satisfaction that they contributed to the result. They think it's fair and equitable. And so that's something that you can get through mediation. Once you get into arbitration, I don't, I think one of the criticisms of mediation and arbitration is that, arbitrators just split things down the middle, 50-50. That's really not the case. And that's not how I've seen it work out in mediation and arbitration. But an arbitrator is really looking at the law as it applies, acting in a sense like a judge. There's generally, there are more formal rules that you would see in an arbitration proceeding than in a mediation. So you as a client and as a participant, you're going to be in a much more formalized channel when you get into arbitration, and your scope of what decision can be made and handed down is going to be less flexible than in mediation. So I think going through a mediation process before you get into an arbitration situation is preferable. But again, going into arbitration rather than going into court, like you said, Matt, you get to pick the arbitrator. When you get before a judge, you may have a highly technical business dispute that's in front of someone that's a judge that spent their whole career as a family lawyer. And if you get in front of a jury, you have 12 people who may have no idea in the world about your business, and they just want to get out of there and get back to their lives. So I think ADR, alternative dispute resolution, from a business owner's perspective, is generally going to be a preferable course and something that in advance the parties are going to want to agree to when they're setting up the company, because of all those benefits that you just mentioned.
Yeah, Rett, I appreciate that aspect as well. That insight was great. I think one of the things, and expanding upon for just a second, in mediation, the mediator can be a little more creative, as you noted. There have been multiple cases that I have mediated for folks where the solution that was the result of the mediation is not a solution that would have been available to the parties through the decision in the court. They came to a resolution that was workable for them. It made sense and it resolved the dispute, but you could not have obtained that result if you had gone the whole way through the litigation to the end and to judgment. So that's a great point. I'm glad you brought up the fact that there's a little bit of outside the box ability when you're dealing with mediation as well. Rett, I've really enjoyed this conversation, as I do all of our conversations. I thank you immensely for taking the time to sit down with us today and talk about business divorce issues and to be a part of the Future Resolution podcast. It was great having you as a guest.
Well, thanks, Matt. I always enjoy, like you said, our conversations about this issue. It's something that we hit on repeatedly, and it's just because we both see a lot of it. You and your role as a mediator and arbitrator, and my own role in looking at companies that come through as clients, and they sometimes have these disputes, and we try to help them resolve them where we can. But as I tell everyone I talk to every day, I think I'm mentioning this, which is as an attorney and as a transactional attorney, I can add so much more value on the front end than I can, once the parties are partway through the process. Whether that's, selling a company, I can, add more value setting up a letter of intent in a transaction than I can at any point else in that process of selling a company or buying a company. I can add more value and save clients money on the back end if I get involved and we do the heavy lifting and setting up their shareholders agreement or their operating agreement. Maybe a client, they're short a little bit on funds, or they think it's a stretch to do that. But from having seen this for many years and having many clients come through the door, it is well worth the investment to have a good set of documents on the front end rather than trying to resolve a set of disputes without those good documents on the back end. And one of the ways that we can help is by electing into this form of alternative dispute resolution in advance, rather than not having it kind of baked into the documents, so that if one party really wants to be intransigent later on when the business is not working out, that that party can't insist on going to litigation to try to get their way. Rather, if both parties have contractually agreed to a mediation and arbitration process in advance, that's going to save their time and resources. So again, the earlier we can get involved on a planning perspective, the more good that we can do for the clients.
Right. That is incredible advice that I try to provide as well. It's really two things. One, it's looking at those legal services as an investment as opposed to a cost, knowing that the investment will stick with you. It's not just a one-time cost. And then also just obviously being proactive as opposed to being reactive. It's so much easier and less costly to be proactive. So those are great points as well. I appreciate it, Rett. Thank you for adding that.
Thanks, Matt. Anytime.
Thanks again for being with me, Rett. I appreciate it.
Great.
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast, Stitcher, Spotify, and subscribe, rate, or review this podcast. Join us soon for another interesting discussion. Thank you for listening.